Have you been told that you need to go through probate, but you're not even sure what that means? Maybe you're trying to manage a parent's estate, or you're planning ahead and want to understand what a probate is, when it's required, how to avoid common mistakes. I'm Elijah Keys, California Certified Estate Planning Attorney. That means I'm like a board certified physician, except I'm board certified as a probate attorney. I've done hundreds of probates and I'm here to talk to you about them. In this video, I'll walk through generally how a probate works here in California, step by step, using the same story of James and Laura, a married couple we've been using in our past videos about post-death transfers. Today, we'll follow them as we navigate probate for a family member's estate, highlighting when it's required, what to expect, and why getting the right help makes all the difference. So what is probate? Let's start with the basics. Probate is a legal process where the court supervises the administration of someone's estate after they pass away. An estate is what someone owns, their responsibilities, and their rights. This process ensures that the debts have been paid, assets have been valued, and are transferred to the correct heirs. In California, probate is required when someone dies with assets totaling more than $206,000, and those assets are not held in a trust and do not automatically pass through something like joint tenancy or beneficiary designation. If that doesn't happen, then there's a probate required. So what does it mean in real life? Well, let's look at James and Laura. Meet the family. Let's do a realistic scenario here. James recently lost his mother, Mrs. Ramirez, who owned a house in Mountain View, California, and had savings in a bank account around $400,000. She had a will, but no trust. The assets were in her name alone, no joint ownership, no named beneficiaries. That means that someone has to be responsible for managing her estate, that's Mrs. Ramirez, because of the value and the way the assets were held. Probate is required. James is named as the executor in his mother's will, but that's not guaranteed that he will serve. He needs to ask a judge for permission. A will is a letter to a judge asking a judge to follow wishes. It's not automatic. So James takes the first step. He files a petition in court. Let's talk about a step-by-step probate timeline. Here's how the probate process plays out for James and Laura step by step. Number 1. File the petition. James hires an attorney who prepares and files a petition for probate in court. That's really what it's called, a petition for probate. Court hearing is scheduled and proper notice is sent to all people who are entitled. Number 2, notify heirs. James must now publish a notice in a local newspaper and mail a copy of the petition and a special notice of the hearing to all the people who are entitled. That includes everybody who's listed in the will and all of his mother's heirs, as well as certain people related to his mother. James has to mail notice to his siblings, who are also named in the will. James also has to mail notice to people who are related to his mother in certain relationships. He has to mail notice to his mother's parents. They've passed away. He has to mail notice to his mother's grandparents. They've passed away. He has to mail notice to his mother's siblings. James is also required to notify all of his mother's children, those who are named in the will, but he's also required to notify his mother's grandchildren. Now, James has 2 children, Leo and Maya, so James is required to notify Leo and Maya. You might say, but they live in the same house. That doesn't matter. James has mailed them a notice. But they live in the same house and they're minors. James is their dad. James could just hand them a piece of paper. I understand, and I agree with you, but the court says James must mail the notice. If James doesn't, the court will reject his petition, the court will require him to mail the notice, and the court will then continue the case for 2 to 3 months later. Just mail the notice. Number 3, appoint the executor. The court appoints the executor. Since Mrs. Ramirez left a will, naming James as the executor, and no one objects, and the court finds James proper, the court issues letters testamentary, that's the document that allows James to act, officially giving him legal authority to act on behalf of the estate. Just so you know, the judge doesn't issue letters testamentary, that's issued by the clerk. If there was no will, James could be appointed as a personal representative, but he would be appointed as the administrator, a different name, and the court would issue letters of administration, not letters testamentary. Number 4, he has to notify creditors. Within 60 days of being appointed as the representative, James has to notify all of his mother's creditors. He has to go through Mrs. Ramirez's mail. He has to go through Mrs. Ramirez's bank account. He has to go through all the information that show who her creditors are, the people that she owed money to. He has to mail the notice to all of them and give them the opportunity to make a claim with the court. Once they make a claim with the court, then James can determine whether that claim should be paid or whether it should not. Number 5, make an inventory of assets and appraise them. An inventory just means a list. So James has to make a list of all the assets that his mother owned. If she owned a bank account, if she owned a retirement account, if she owned a house, if she owned a car, if she owned a horse, if she owned property in England. If she owned something, then James has to keep it on a special list called an inventory. James has to send that inventory to a probate referee, that's a court-appointed appraiser, who is going to appraise his mother's assets. Now, as we said, James's mother, Mrs. Ramirez, owns a home, a bank account, and certain personal items. But some of those are actually very valuable jewelry. And so James sends a list of the assets to the probate referee. The probate referee values those assets and sends the list back to James. The probate referee lists a value for the house, which is similar to a value that you might consider like an appraiser. And the probate referee also values the jewelry. But here's where things get tricky. The probate referee is not an expert in valuing jewelry. They don't know how, but they're the one who has to value the estate. So the probate referee will reject the request from James, tell James to go hire a professional appraiser, have the appraiser appraise the jewelry, send the appraisal and the inventory to the probate referee so the probate referee can verify whether the appraisal is proper and then list the appraiser on the page. I'm not telling you what's proper, I'm just telling you what normally happens. The inventory and appraisal form has to be done on a very specific document. A lot of places in California, attorneys are required to use something called judicial counsel forms. There's a group with this California State Bar called the Judicial Council, and they simply come up with ways to make courts more accessible to the public. Oftentimes what it does is it makes courts more difficult to the public because nobody understands the forms and they're very complicated, and sometimes they're backwards and sometimes they don't make sense, and sometimes they don't contain the things that you need to say, but you have to say them anyway. So you have to find a way to say the things without saying them on the form that you're required to use, but you don't need to use the form if you're in another state. Welcome to being a lawyer. Number 6, pay debts, taxes, and expenses. James, using estate funds, is required to pay creditors that are valid. So let me tell you that the IRS and the Franchise Tax Board get to be paid whether or not they make a claim. For all other debts, those are things that James gets to determine whether those debts are right or wrong, whether they should be paid or shouldn't be paid. This is where things get really tricky because if somebody makes a claim and James says, no, I don't want to pay it, then that person now has a right to sue. And if they sue in probate court and the judge determines if the debt is valid after a trial. James will also have to pay expenses. There will be expenses of the administration. James will have to pay for appraisals, and he'll have to pay for the probate referee, and he'll have to pay for the attorneys, and he'll have to pay for court fees. It's a lot. You just have to pay these people. Number 7, distribute the assets. Once debts and taxes are handled, once assets have been inventoried and appraised, James can file a petition for final distribution. In that petition, he asks the court to approve dividing the remaining estate according to the will. He lists the assets that are available. He lists what people are entitled. And at the same time, he must file an accounting. An accounting is a court record, a very formal record of income, expenses, assets, and distributions. It's not like an accounting like your tax return is done by an accountant. It's not the same thing. It's an accounting to show the judge in a very specific proper form how assets are actually valued in a probate. It uses the inventory and appraisal, it uses the bank statements, it uses asset values, it uses sales, it uses purchases. It is very detailed. This is where you want to hire a professional, absolutely for sure. If it's wrong, the court will reject your petition. After distribution, each sibling receives their share and must sign a receipt stating that they received it, and then James files those receipts with the court. Finally, number 8, close the estate. After the court approves the first accounting and distribution, and after the assets are distributed, there will be other expenses. James might have to pay for a final tax return. There might be other issues to deal with after the distribution is done. Oftentimes, James would retain what's called a reasonable reserve. Reasonable, there's no set number. It doesn't mean $100, $1,000, $5,000, $10,000. I've seen reserves of $200,000. It just means what are the expenses remaining to pay that we might expect to be seen, plus some additional money for unforeseen emergencies or circumstances. After all those expenses are paid, James then asks to be released as the executor, and the court does so, and the court then instructs him to give the rest of the money to the beneficiaries. Now James is done. The longest probate in history, 57 years. The shortest probate that I've ever seen, 11 months. The shortest probate after COVID, 2 years. Why an attorney helps. Now, could James have handled the probate alone? Absolutely, he could. Realistically, especially with court rulings, legal notice requirements, potential disputes, it's easy to make simple mistakes. 3 or 4 simple mistakes when combined can be really expensive and can cause delays. Also, James's siblings want their money. They're entitled to it. And any delays caused by James, they could get really mad. I know they get along now and everything's okay, but eventually too many delays, their patience will run out. This is where a qualified attorney comes in. An attorney can help guide the executor through the process, ensure compliance with court deadlines, handle paperwork and filings, reduce the likelihood of family disagreements, protect the executor from personal liability. No one protects the executor, but the court is required to hold the executor to a very high standard, and the siblings are not required in the same way. That person deserves protection too. You really should think about hiring an attorney. Probate doesn't need to be a nightmare, but without legal help, it can quickly become overwhelming. We support families every step of the way. A good certified specialist attorney can help. Can probate be avoided? Here's the part many people miss. Probate is often avoidable with proper estate planning. James and Laura, after going through the probate with Mrs. Ramirez, decided to set up a revocable trust for their own assets. This means their kids, Maya and Leo, won't need to go through probate in the future because the trust will privately and efficiently distribute their estate. Planning ahead can make all the difference. So let's recap. Probate is required when someone dies with significant assets outside of a trust or beneficiary designations. It involves a formal court process and can take more than a year, sometimes more than 2. Executors are legally responsible for handling everything properly. An attorney can make that process much less stressful and more streamlined. If you're dealing with a probate or want to avoid probate through planning, make sure that you contact a certified specialist in probate law. They can actually help. They're really good at this. If you've made it this far, thanks for watching. Don't forget to like and subscribe so you don't miss any of our videos. Share this video with someone who you think could use this information, and follow along so we can help you develop the keys to your legacy. We'll see you next time.